Hi guys, this is Erica from Gokce Capital. Now before I begin, be sure to click subscribe and turn on the notification bell. In December of 2000, 85-year-old Galina Kluge entered into a contract for sale on 2 apartments in Manhattan worth $14,500,000. Upon execution of the contract, her lawyer placed the buyer's deposit in an escrow account, and a few months later, the deal closed. However, when her lawyer went to withdraw the escrowed deposit, his check bounced. It seems the deposit was lost. So what happened, and who is responsible for the lost funds? We'll find out at the end of this video. But first, if you are closing on a sale or purchase of real estate, you will likely be using an escrow agent to handle deposited funds. So in today's video, here are the top things you should know. Number 1, an escrow agent is a person or entity that holds funds in trust for third parties while a real estate or financial transaction is finalized. The role of an escrow agent is often played by an attorney or title company who has the fiduciary responsibility to both parties. Number 2, escrow comes into play when both the buyer and seller sign a purchase agreement. The vast majority of the time, the purchase agreement will require an earnest money deposit on the part of the buyer that will be placed into an escrow account. Once the contract is signed and the deposit made, the escrow agent will then begin working to get everything in line for closing. Number 3, the escrow agent handles any escrowed funds, but also often serves other roles in the closing process. Of course, they hold on to the earnest money deposit, but they also align all documentation for the ownership transfer, in many circumstances conduct a title search and issue a title insurance policy, release the escrow account funds to the required party once the deal completes or falls through, and files the deed. Number 4, any escrowed money is kept in an account until the closing occurs. The account is usually an FDIC-insured account or an investment vehicle such as short-term treasuries or money market mutual funds. But the escrow agent will be the one to handle what type of vehicle the escrowed deposit is placed into. They should, however, disclose where they are placing the funds. Number 5, if one of the parties defaults on their obligation under the contract, then the non-defaulting party typically has remedies available. What will happen if a default occurs is that any money placed in escrow will be held until the dispute is settled. At this point, the escrow agent is normally instructed not to release or refund any of the money. Number 6, when a dispute occurs between 2 parties in a contract, the escrow agent may file an interpleader action if they are concerned that they may be held liable should either party be unhappy with the resolution. This action requires the escrow agent to place the money into the court's custody, at which point the escrow agent can be dismissed from the deal. Number 7, if you have an escrow agent as part of your closing process, it's a good idea to request an escrow agreement in writing. This way you understand what will be happening with the deposited funds. You should consult with a lawyer on the specifics of your escrow agreement, but typically these agreements include the names and addresses of the depositor, the escrow agent, and the beneficiary, the amount of the escrow deposit, the name and address of the bank where the escrow money will be deposited, as well as the account details, whether the escrow agent is required to use an interest-bearing account, the conditions before which the escrow agent can release the escrowed funds, the time limits for the performance of the escrow agent's duties, and the duties of the escrow agent in the event that the conditions of the escrow agreement cannot be met. Number 8, escrow agreements should require interest-bearing accounts when escrow funds can generate significant interest. Different states have different laws regarding this, but it's often negotiated whether the funds must be in an interest-bearing account. The larger the deposit, the greater interest you may have in using an interest-bearing account. However, it is often the case that non-interest-bearing accounts are used. For example, in New York, lawyers are permitted by state law to use interest on lawyer account funds for small and short-term escrow deposits. Interest earned on these accounts is pooled and used to finance civil legal services for the poor. Number 9. There are some things you should do to protect your deposit if it is going into escrow. Make sure that your money is deposited by a certified check. Review the endorsement on the check and confirm with your bank that it was deposited. Be very wary if an escrow agent delays releasing the escrow funds or property. And of course, be especially wary if there is a bounced check. But let's return to Galina Kluga's lost $1 million deposit. In December 2000, Galina put up 2 cooperative apartments for sale in the same Manhattan building at a price of $14,500,000. She found a buyer within a few months who signed a contract and agreed to pay the 10% deposit. Galina's lawyer was to serve as the escrow agent and deposited the earnest money deposit in a non-interest-bearing IOLA account with the Connecticut Bank of Commerce. In March of 2001, a dispute arose between the buyer and seller over the kinds of alterations that would be allowed by the co-op board, and the deal fell through. A case was opened to determine who was entitled to the deposit, and the lawyers for both Galina and the original buyer agreed to have the funds moved to an interest-bearing account. Meanwhile, in March 2002, Galina entered into a second contract for sale for the 2 apartments at a new price of $12,800,000, and a deposit of $1,280,000 was placed in a non-interest-bearing account with the same Connecticut bank. This time the transaction occurred, but when the lawyer went to withdraw the deposit from the escrow account, the check bounced. It turns out that 2 days prior to the closing, the bank had been shut down by bank regulators. Now, the account did have FDIC insurance, but this only paid $100,000, which is what Galina received, along with about a third of the original amount from the sale of the bank's assets. One other key point here is that it turns out that the deposit from the original sale, which fell through, never ended up being moved. Thus, that deposit was lost as well when the Connecticut Bank went under. For this reason, the buyer from that original transaction opened a suit against Galina and her lawyer over the loss of his deposit. As part of the suit, Galina opened her own claim of negligence against her lawyer for placing such large sums in a relatively small bank without obtaining supplemental insurance. An initial ruling by the New York Supreme Court determined that Galina's claim of negligence against her lawyer could move forward. However, in 2005, the appellate division of the Supreme Court later ruled that the claims should have been dismissed, for there is no requirement under New York state law that a lawyer must place funds in a fully insured account. Furthermore, there was no way for the lawyer to know that the Connecticut Bank was in danger of closing. So, in this case at least, it seems the escrow agent is not responsible for the loss of funds. But more importantly, for you as a real estate buyer, this case highlights a hidden lesson. Be very careful about entering into purchase and sale agreements. You should be near certain you want to close on the deal. After all, there's no guarantee that you will get your deposit back. Now, do you have any stories or comments about escrow agents or closings? Let us know in the comments. Did you like this video? You're going to love our Gokce Land Due Diligence program. We'll make you a land due diligence expert in just 7 days. Check it out at gokcecapital.com/glad. And while you're at our website, don't forget to explore our $1 down listings at gokcecapital.com/listings. Finally, don't hesitate to reach out. You can email, call, or text, and we will respond as soon as possible. So thank you for listening, and more to come.